Good evening and welcome everyone to our legal forum this evening. This forum is part of the Orange County Clerk of Court's Legal Matters Forum series, and this evening's topic is on guardianship. I'm Dane Weister, the Communications Director here at the Orange County Clerk of Courts. Thank you for joining us. Of course, we hope you find the information provided during this free legal forum informative and useful. And you'll be able to type in any questions you might have through the Q&A function that you see on your screen towards the bottom. And we'll have a question and answer segment at the end of our webinar to answer any questions that you've submitted. We'll try to answer them as best we can. And we also ask that you help us by filling out a survey at the end of the presentations and at the end of this webinar. Now, this webinar is being recorded. It is being posted on our social media channels as well. It's also streaming live on our Facebook channel for the Clerk of Courts. And so it will be available on our website, social media channels after tonight. If somebody does not get a chance to catch all of our webinar here in its live format. Orange County Clerk of Courts, Tiffany Moore Russell, sends welcomes, and she'll be joining us towards the end of our presentations. So what we're going to do is we're going to jump right into our first presentation, and we have presentations here tonight by a deputy clerk from our office. We have also from court administration, a court monitor. We also have a local attorney who'll be sharing some information. And then also we even have a judge that is here with us, and we're honored to have all of our presenters. So let's jump into the first presentation. And we have our Clerk of Court Senior Deputy Clerk, Métis Moxley, who is going to share with us our role and services here of our office at the clerk's office and what we provide when it comes to guardianship. Métis.
Hello, thank you. As Dane said, my name is Métis Moxley, and I'll be presenting for you today Guardianship 101. And I'll be sharing party definition, types of guardianship, guardianship case type, clerk's role, guardianship FAQ, and how to contact us. We'll begin by starting with party definitions and types of guardianship cases. We have 3 parties listed here, and our first one is a petitioner, and that's someone who files a petition with the court seeking appointment of a guardian for a person alleged to be incapacitated. And that typically is filed with a family member, a professional guardian, or a facility to be filed with an attorney, obviously. Guardianship is a surrogate decision maker appointed by the court to make either personal or financial decisions for a minor or for an adult with a mental or physical disability. An award is a minor or incapacitated adult placed under protective or legal guardianship orders by the court. We have 2 types of of guardianship. We have limited and plenary. A limited guardianship it's appropriate if the court finds the ward lacks the capacity to do some but not all of the tests necessary to care for his or her person or property, and if the individual does not have pre-planned written instructions for all aspects of his or her life. And a plenary guardian is a person appointed by the court to exercise all delegate legal rights and powers of the adult ward after the court makes a finding of incapacity. Wards in plenary guardianships are, by definition, unable to care for themselves. The easy way to remember this, a limited, some of the rights have been removed and not all, but the plenary guardian has every of their rights removed. Guardianship case types. We have guardian of the person and property. The guardian has the authority to exercise the personal right and or property rights that have been removed from the ward and delegated to the guardian, and they must file the required initial report and annual report with the court. A guardian advocate is represents a person that was born with a disability. That could be a person born with autism, Down syndrome, or spina bifida. And this is the only case type that does not require an attorney. However, some attorneys do file it, and it's okay. Minor settlement is a guardian Guardians are appointed in this case where a minor receives a net settlement that more than 15,000 because of personal injury, property damage, or wrongful death lawsuit. The court, without adjudication of incapacity, may appoint a parent, sibling, next of kin, or another person interested in the minor's welfare as the guardian. We now go over the clerk's role in guardianship cases. In addition to being the keepers of the record, effective monitoring of guardianship cases is a critical role of the clerk's office. This includes ensuring that all required reports are timely filed, and as per Florida statute 744-368, the clerk audits the initial plan, verified inventory, and accountings. Guardian of the person, they must file an initial guardianship plan 60 days after their appointment and an annual guardianship plan a year later on their anniversary. The clerk's review of these plans ensures that they address the following. Not all were listed here, but we've provided for the medical and mental health care of the ward, the residents of the ward, personal and social service of the ward, and the annual determination of capacity and any rights that can be restored. The clerk also ensures that a physician's report is submitted with the annual plan. Guardian of the property must file a verified inventory 60 days after their appointment, the annual accounting a year later on their anniversary date. The inventory must include all properties of the ward, real and personal, that has come into guardianship possession or knowledge, and that's once they're appointed. The annual accounting is a full and correct account of the receipts and disbursements of the ward's property that the guardian has control of. It will also include statements of the ward's property and on hand at the end of the accounting period. Audit process. Now, these are processes that we have in the clerk's office. And first, we'll give you the audit defined, which is an audit is a systematic review of financial and all other documents to ensure compliance with 744-368 rules of court and local procedures using general acceptance accounting principle. The terms include various practices that meet professional standards such as verifications, review, and substantiating papers and accounting, interviews, inspection, and investigation and findings. If the documents file are in compliance, the clerk will prepare an order approving the report to send to the judge. If the documents file are not in compliance, the clerk will prepare a report of auditor to send to the guardian or the guardian's attorney. The report of auditor will explain what is needed for the guardianship to comply. If they do not comply with the report of auditor, an order to show cause may be entered. Sorry. Yeah. 1 second. Examples including but are not limited to transactions not approved by court, service was not provided to the limited ward, bank statements for the wrong time period, the accounting file is for the wrong period, financial schedules do not reconcile, and missing registration from bank statements. We have the guardianship FAQ. You can find this information available online on myorangeclerk.com. And this part is for the guardianship, but you will also find information for other departments. These are our most commonly asked questions here. Why does my case say it's closed online? Once a guardianship is appointed by the court, the case goes to closed status for reporting purposes. However, it is still active for the life of the ward unless a final close is ordered by court. Difference between a party and a participant. A party is considered to be a ward and the guardian. They both have full access of the cases, and a participant is an interested party that has limited access to the cases. Will an incapacitated person lose his or her driver's license? Yes, by order of court. Driving privileges will be revoked. How soon can I be appointed the guardian of an incapacitated person? The court may appoint an emergency temporary guardian if necessary. This type of guardianship usually is appointed within 48 hours. A guardian of the person, a guardian of the property, or a guardian of person and property will usually be appointed within 30 days. You can always contact us should you have any questions or concerns at myorangeclerk.com. You can click on contact us on the right-hand side corner of the web. You can select appropriate divisions, so you can ask any questions. We'll get the questions. We'll try to get to them immediately and send you an answer. Or you can contact us at 407-836-2000, option 6. Or you can come in person at 425 North Orange Avenue, room 355. And at this moment, we have our manager, Michael San Giorgio, and Tamika Brown is our assistant manager. If you have, I hope that this slideshow was informative. And should you have any questions, please contact us. Thank you.
Thank you very much, Métis. So we actually do have a question that came in during your presentation. I think that is relative to what you were speaking about. And so we're going to take a look at that question that came in the Q&A. The question is, are you saying every Florida child who is the beneficiary of a settlement of at least $15,000 must have a court-ordered guardian? That was the question. Every Florida child who is a beneficiary of a settlement of at least $15,000, do they have to have a court-ordered guardian?
If it's less, no. If it's more, yes.
Actually, can I jump in there for a minute?
Yeah.
With the judge's perspective on this?
Yes.
The statute says shall. There is a provision in the statutes that allow courts to find less restrictive means. So in Orange County, generally, Ms. Moxley is correct. If your settlement is over $15,000 or you've inherited over $15,000, a guardian is going to be required. However, if the settlement is paid as an annuity, which can't be touched by the parents or anyone else, then we will oftentimes waive the guardianship requirement and allow the annuity to stand as a less restrictive means.
Okay. Thank you, Judge. And I didn't get a chance to actually introduce our judge. We have Judge Leticia Marquez, who is with us tonight as well for our webinar. So thank you. Great information. Also, we have another question that's come in, and we could take a look at this briefly. Does the guardian have to be a professional? Well, yes. Does the guardian have to be a professional, or can a parent be the guardian? Whoever would like to try to help answer that.
I guess everyone's waiting for me. A guardian does not have to be a professional. Parents can be guardians, and we actually have a preference for parents or family members to serve as guardians.
Okay. And then we'll take one more question here, and then we'll move on to our next presentation. And the next question is, could you elaborate, please, about the driver's license limitation, if any? And I believe that was where we were speaking about that the driver's license would be revoked.
It isn't revoked in every case, but it depends on the condition of the incapacitated person and what capacities they still retain. It is one of the more common things that are removed because oftentimes with finding of incapacities, folks are suffering from dementia, confusion, that type of thing with adults. And so it's dangerous for them to drive, but that is up to the examining committee members and the recommendations they make to the court.
Okay, great. Thank you, Judge. Okay, so we're going to move on to our next presentation. Now, again, you can continue to enter any questions you have into the Q&A function at the bottom of the screen, type them in, and we will get to them. We try to get to most of our questions after all the presentations, unless it has something directly to do with our speaker. So up next, we now have a presentation from Court Program Specialist, Winter Solomon Cuthbert, who is with the 9th Judicial Circuit Court Administration. She has details on her role in services regarding guardianship. Thank you for joining us, Winter.
Hi, good afternoon. So I'm going to kind of tell you how we got to this position where guardianship is so much in our purview, I guess. Between the years 1900 and 2020, the elderly population in the United States increased more than 17% from 3.1 million in the year 1900 to 55.7 million in the year 2020. According to the November 2022 Administration on Aging report, 17% of people living in the United States is 65 years of age or older. Over 4.6 million Floridians, or 21.3%, are 65 years old or over, compared to the national average of 16.8%. In fact, the state of Florida has the highest percentage of residents over 65 than any other state in the union. By the year 2040, the Administration on Aging expects the population of people over 65 in the US to reach 80.8 million residents, which is double the number in the year 2000. The population of those 85 and older is projected to climb from 6.7 million in 2020 to 14.4 million in 2040. Next. The aging of the baby boomers has brought about a dilemma for their adult children, many of whom are still in the midst of child rearing. Medical science has not only helped the elderly live longer, but children survive with conditions that years ago would have almost certainly caused them to die before reaching adulthood. Not many years ago, people with mental illnesses or disabling conditions were sent to facilities where they were locked away to spend the rest of their lives. In the 70s and 80s, the doors to the mental health facilities were unlocked, and those not a danger to themselves or others are no longer being held. These things, in addition to the privacy protection put in place by the Healthcare Insurance Portability and Accountability Act, and the need to protect those who can't protect themselves, has brought about the ever-increasing need for guardianships and court oversight. Next. What is guardianship? Guardianship is a legal relationship created by law, giving another person, the guardian, the legal right and duty to exercise specific rights that have been removed from another person, the ward. The guardian makes the surrogate decisions, or is the surrogate decision maker. Guardianships can be guardian of the person, guardian of the property, guardian of the person and property, or limited combinations of one or both. Next, please. Why is guardianship needed? Sometimes guardianship is needed because the subjects of guardianships fail to properly prepare for life situations that rendered a person unable to express how he or she wants to be cared for, who should care for him or her, and who should handle his or her property if he or she is unable to do it. In other cases, guardianship is needed because the person is born with a severe developmental disability that prevents him or her from exercising and understanding the rights we all have when we reach the age of 18. The untimely death, imprisonment, or absence of a minor child's parents often results in the filing of guardianship to determine who will make decisions on behalf of the minor. Next, please. Because a child cannot own property, if he or she receives more than $15,000 in property, be it money or other property, a guardianship is done to determine who should manage the property on behalf of the minor. Parents are not automatically the guardian of the property of their children. Cases involving the chronically mentally ill will sometimes result in the appointment of a guardian. Guardianships are frequently done because siblings or family members are at odds with one another, or perhaps are at odds with a step parent about the care and property of the parent. Whatever the reason, Florida Statutes Chapter 744 provides for the appointment of a guardian to protect the ward and preserve the ward's assets for later use by the ward. The road to guardianship. Guardianship of adults, what happens is there's a petition for incapacity, a 3-person examining committee is appointed, an attorney is appointed for the ward, a guardian application is filed, and whoever's applying to become the guardian must undergo a criminal history check, And if they're wanting to become guardian of the property, they have to undergo a credit check. In Orange and Osceola counties, we do those credit checks ourselves. Once those reports are received from the examining committee, then a hearing is held and a determination of incapacity is entered, or the person is determined not to be incapacitated. For guardian advocacy, a petition for guardian advocacy is filed along with medical and social history records. An attorney is appointed for the ward by the court. A guardian or someone wanting to be the guardian files an application. There again, they have to do the criminal history check. And if they're going to be guardian advocate of the property, they have to undergo a credit check also. And a hearing will be held about determining whether or not that person actually needs a guardian or guardian advocate. Next, please. You can see that there are many rights that are retained by a person who is legally incapacitated, but there are rights that are removable also. Those rights are the right to marry. If the right to enter into a contract has been removed, the right to marry is subject to court approval. The right to vote, to personally apply for government benefits, to have a driver's license, the right to travel, the right to seek or retain employment. Those are rights that can be removed. Okay, but there are rights that can be removed that can also be delegated to someone else, which, like the right to contract, the right to sue and defend lawsuits, to apply for government benefits, to manage property or make a gift of property, to determine residence, to consent to medical or mental health treatment, and to make decisions about where or with whom you live. Those are all rights that can be removed and then assigned to someone else, the guardian. Okay, next. After being appointed, the guardian of the person must file an initial plan within 60 days of the date of letters. They also have to complete and submit an annual report and a physician's report every year. They must attend the court-approved guardian education course within 120 days of being appointed. If you're guardian of the property, your job is to marshal the assets of the wards. Marshaling the assets, that's just the fancy way of saying, gather all the assets, get them together, and put them someplace for safekeeping. That person who's the guardian of the property has to file an inventory within 60 days of letters, and they must also file an accounting annually. The guardian of the property must also attend the court-approved guardian education course within 120 days of appointment. The court retains oversight of all guardianships. Why does the court retain oversight over guardianships after the appointment of a guardian? Okay, next slide, please. So this is why. These are all reasons why the court retains oversight. In the first picture, you see a little girl's leg. Initially, her sister was her guardian, but her father, the little girl's father, who had been in prison, got out of prison and came and took the little girl home with him. The guardian sent in paperwork to the court, and the court ordered the child be returned to the guardian. So the guardian did go and pick up the little girl, went and took her to go get some clothing. And when she took her into the dressing room to be fitted for clothing, this is what she found. Her father had beaten her with a belt, the buckle end of a belt. He eventually ended up going back to prison for some time, and then was on probation and did not have any contact with that little girl until after she reached the age of 18. The second and third picture are of the same person. This gentleman was a veteran and he had had a stroke. He had limited use of his left side and no use of his right side. He had been released from the hospital and his mother was there. So she picked him up and took him home with her because she didn't like the ward's wife. And then she went and filed for guardianship. Well, the court appointed me to go see how the ward was doing. And after many visits, the wife had decided she wanted to take him to get some clothes. So in taking him to get some clothes, we took his shoes off and we found his foot in very poor condition. He was also diabetic and mom wasn't caring for his health as she should have been. And he had a skin disease on his back and he was living with his mom. His mom was not taking care of him. Needless to say, he did not go back into the care of his mother. The pictures down on the bottom are, that's the home where a girl who at the time was 15 years old, her mom had been murdered and she and her sister were wards. And after all of the property was, had come in and everything, the daughter who was 15 should have had $62,000 in her bank account. Well, the father failed to, and the guardian failed to file his annual accounting. So I was appointed to find out what was going on. So I went to the bank and I found out that instead of having $62,000, the child had $2.22. And so then I went out to see the child at school and she told me she thought no one would ever come for her. So that evening I went to see her at her home and this was the there we go. This is the condition of the home that she was living in, even though her father was receiving roughly $1,100 a month for from Social Security benefits for her care. This is the home that she was living in. She was living in a home that didn't have a refrigerator that cooled, didn't have a stove that heated, and the father had taken all of the tile off of the wall. So needless to say, she didn't go back to that home that night either. Next, please. This gentleman lived in the only, the gentleman on the right, well, never mind, she already did it. Okay, so the next picture. Okay, so the picture with the cigarettes and the Harley Davidson and the paper that's right next to it and the paper that's down on the bottom, those are all from the same case where two children were, they inherited money from the death of their father who was killed in a work-related accident. Mom was not married to the father. They'd been divorced for over 15 years. And they also had a workman's comp settlement and a personal injury settlement. Altogether, the children should have had roughly $186,000. Mom spent every cent of it. She used their money to buy the Harley that you see that she's on right now. She used it to buy cigarettes. She got $7,500 worth of liposuction. If she went to the grocery store and bought a Coke, she used their money to buy a Coke. She used their money for a lot of things. She bought a house that later ended up going into foreclosure. That child was able to get the money back because there was a lien that was placed on that house. And when it was actually sold, because the company did not do their due diligence, we were able to get the child's money back. So they were able to get their money from the sale of that house, even though it had gone through or was supposed to go through a foreclosure. The other ones are the other pictures. We have a picture of someone bought a Mercedes. I guess because they just wanted a Mercedes to take their child around in. And that's not something that's necessary. There's also someone paid for their BJ's Wholesale Club membership, and someone bought wine for with their ward's money, and the ward was a minor. So those are all things that this court frowns upon. And when we find that those things happen, those cases all get reported to law enforcement. Can you go to the next picture or the next slide? So I call this one when things go sideways. When the court has reason to believe a ward is being exploited, abused, neglected, or a guardian has abused his or her power, or if the court simply needs more information, Florida Statute 744.107 allows for the appointment of the court monitor. The court monitor is allowed to investigate, seek information, examine documents, interview the ward and others who may have information, and report the findings to the court. In this circuit, that is me, and we do investigations here. We collaborate with law enforcement. I will run your credit. I will examine your bank records. We will go to whatever depth we have to find out what's going on with our ward's property and to make sure that their property is secure and that a person who is mishandling the money will no longer be able to handle it. Next slide. Repairing what went sideways. After the court monitor has been appointed, an investigation is done. As I said, we do background checks, we do credit checks. I will go out and talk to neighbors, friends, relatives, the ward, physicians, nurses, bankers, and others who may have information pertinent to the case. We also freeze bank accounts, IRAs, CDs, and other financial accounts. We obtain and evaluate financial records, obtain medical and psychological records, school records, military records, whatever records that we deem necessary, we will obtain those and review them. We coordinate with law enforcement agencies, the Department of Children and Families, Medicaid, Fraud, Department of Insurance, the Florida Attorney General, Agency for Persons with Disabilities, and Agency for Healthcare. Those are all agencies that we regularly collaborate with and try to get information from if we have a case that involves them. Upon court approval, we also refer those cases to law enforcement for additional investigation and arrest, as well as to the Office of the State Attorney for prosecution. Really, the court is the ultimate guardian. The court is the ultimate guardian and will do what is within its powers to protect those under its authority who cannot protect themselves, including, but not limited to, removing guardians and appointing a new guardian, requiring reimbursement or repayment of misused funds, approving the assessment of liens when appropriate, requiring the bad actor to pay the cost of the investigation, including paying for records requested from banking institutions, medical records, etc. And guardians should know they serve at the behest of the court, and the court retains oversight of all guardianships. And that's it. That's the end. If anybody has any questions, I'm here.
Yes, all right, thank you, Winter. So yeah, a lot of insightful information into also what you do as a court monitor. So we do have questions coming in, and before we get to our next presenter, I wanted to go through at least 3 of those that came in and were being answered. So they're being answered by our judge. Thank you, Judge Marquez, for answering those. But we want to share with everybody the questions and answers so that everybody, all of our participants get to hear these questions and answers. So I'm going to go through these 3 real quick. So the first question that was answered was, if I have a child that cannot take care of herself, do I have to get a guardian? She's over 20. So Judge Marquez said that once a person turns 18, a guardian is required in order to make decisions for them. The second question was, my son has autism. He turns 18 in January. When should I apply for guardianship? And the judge's answer was, you should start the proceedings before he turns 18, but can apply after if for some reason you're unable to complete the process prior. And then our third question that was answered by our Judge Marquez, can a durable power of attorney be an option instead of guardianship if the person is not completely incapacitated? The answer, complicated question, but yes, a durable power of attorney can be used with other documents to avoid guardianships. And we're sure that our next presenter, Mr. David Brennan, will be able to explain those. So there you go. That's my next segue into our next presenter, which is David Brennan, who is an attorney who's here to give us some more details from a legal perspective. Take it away, David.
Need to share?
They can see you, so you can talk.
Hello, everybody. I've got to share my screen with everybody, I think. So let me do that. Is it there?
Hello.
Where?
Right there.
Yes, and while you're doing that, I wanted to share with everybody that if you're just joining us, because we've had some people come in a little towards the middle of our presentations, that you're joining us for the Orange County Clerk of Courts Legal Matters, Legal Forum on Guardianship. And there you go. So thank you for joining us, and you can enter questions into the Q&A function at the bottom of your screen. So go ahead, David, take it away.
Okay, that picture to the left of my screen, wherever it is with yours, is some younger guy who used to be me. I do not know what happened in the meantime, but let's get started. My purpose in life tonight is to talk about the attorney's role in guardianship proceedings. First of all, if I mess up anything here, it's because I haven't bothered to learn any technology or internet related things, because I know that it is just a fad, and we'll be going back to live presentations very shortly. In the meantime, here's a little perspective. There is a representation of all of the people in the entire world who ever lived. And here's a statistic, and I can't prove it, but I believe it to be true. 2/3 of all people who have ever lived on Earth to be 65 years of age are alive today. I know that Winter addressed this a little bit, talking about all of the millions of old people like me who are in Florida, with more coming all the time. But that is a sobering and likely true statistic that I have just given you. This really puts a premium on knowing about and understanding the need for guardianship for all of these elderly people who are coming on to be with us, hopefully, for some period of time. Okay, Act 1. Why do you have lawyers in guardianship cases anyway? Well, there are a couple of underlying things that everybody needs to understand. The purpose of the guardianship with the involvement of a guardian and a ward and an attorney is to me a sacred kind of relationship. The ward is the most important person in the entire process. The guardian has basic responsibility for caring for the ward and or the ward's assets. The attorney represents the guardian in carrying out the guardian's functions. I'll have a little bit more about that momentarily, but here's the underlying thing that is important. both the attorney and the guardian have direct obligations to the ward. This is an extremely important obligation. So the attorney not only has an obligation to competently represent the guardian, but also to care for the rights and protection of the ward as well. Now, I'm not sure why I have this slide here, except that I saw it on a nice stroll through a small town in Scotland, and I thought, isn't it nice that they warn all the other people about people like me walking through their town? I'm going to back up from that just a second and talk about the protecting issues. Guardianship is a highly technical operation. So many people are vulnerable, with more coming all the time. It's important to have a structure that protects those people and protects their rights. Due process protections, making sure that their confidential information is not spread upon some record. And so this is kind of the underlying feature for what I'm going to say from this point forward. Now, Act 2. We have these lawyers, and what do? Mady told you that in almost every case, you have to have a lawyer involved in a guardianship. That's because that's what the law says. And it's also because of the complexities of the operation in the very first place. The lawyers do a lot of stuff. It is not the lawyer's case directly, but the lawyer is the person who knows what has to happen, because the lawyer, theoretically at least, is familiar with what goes on in a guardianship and has done enough of them to be able to efficiently and legally carry out the obligations that exist. Now, there are so many things that lawyers have to know to be able to carry out the functions. There we go. Don't write any of these things down because it doesn't matter at this point. I'm going to tell you what the point of this slide is. And by the way, I couldn't put everything on one slide, so there's other stuff as well. We have the guardianship law, which is about 60 pages of very tiny little fine print. There is also the Florida probate rules, which has 2 sections on guardianship work. And the attorney is charged with knowing those things so that the papers can be prepared as necessary, and so that the rights of the ward are protected and the duties of the guardian can be carried out honestly and effectively. It's not just the guardianship statute itself, which is section 744. It is all these other sections, because it's necessary to know who a person's heirs are. It's necessary to know if there are advanced directives, such as healthcare surrogate designations. It may be necessary to convey various property interests in the course of a guardianship, and the lawyer needs to know the provisions for that. Recognizing and addressing exploitation and abuse of elderly people, and not just elderly people, by the way, is an important feature at all. A guardian may be charged with bringing a legal action against one or more persons for exploitation or misappropriation of a ward's assets or direct physical abuse. It's necessary to understand transfers to minors, and sometimes there are trusts involved that a ward had created prior to incapacity, and the attorney needs to be aware of and understand the implications of all of those things. More stuff. Another feature is psychology. The lawyer is dealing with a very charged situation often, with the family members who are not always happy with each other or with the guardianship system itself. Child psychology. This does not mean I'm talking about guardianships for children. I'm talking about that, but I'm also talking about guardianships for adults and the people around them, either the adult children or the nieces and nephews, or whoever might possibly fight about something and do, and who act like children. The guardian and the guardian's attorney have to be able to address that, and in a diplomatic way. So, and I'm going to go back to that. I think I went too fast. The old Will Rogers statement is as applicable today as it always was. It ain't the things you don't know that hurt you. It's the things you do know that ain't so. And this is an area of the law where there is a lot of things that people know that ain't so. The lawyer has to get through all those things and prepare the proper documents and know what those documents are that should be prepared in the first place. So let's go on now and talk about, there you go, Act 3. We're going to start a guardianship. And the first thing that happens in most adult guardianships is someone files a petition to determine incapacity. Now, I know that Mady and Winter talked about that in a very helpful way. There is always one or two, usually two attorneys involved at that initial process. Someone will file a petition to ask the court to make a determination as to someone's incapacity. That one of the first things the court will do is appoint a separate attorney to specifically represent the interests of the alleged incapacitated person. Now, I'm going to stop here and say something nice about our system here in Orange County. Some of you out there may have cases from other counties, or you may encounter guardianships that have started in some other jurisdiction. Unfortunately, guardianship is not a uniform procedural process. The law is the law, but the way it is carried out varies from county to county. Think in terms of the original Star Wars cantina scene with all the different life forms. That is really what we have. And so the beginning filing of a petition to determine incapacity is done in Orange County right, and it's done better than in most other counties that I have encountered, and I've encountered a lot of them over all the decades and centuries that I've been practicing this kind of law. The court is going to appoint an examining committee, but the court is, to me, most importantly, going to appoint an attorney to represent the interests of this person who is in distress. That attorney will proceed through any hearing on the incapacity case to the point of there being a determination as to whether the person is incapacitated or not. Now, the second attorney is the one who has filed the petition to determine incapacity based on information provided by a client, who may be a family member. I would say most often is a family member. And then once that hearing has been held, the court will go immediately into a determination of who should be the guardian for this person if incapacitated, and sometimes whether there should be a guardian appointed at all. It is not required that there be an appointment of a guardian if there are sufficient safeguards to avoid that. In my experience, usually a guardian needs to be appointed to some extent, even if there are, for instance, powers of attorney or trusts or other kinds of estate planning documents. And the reason for that, in my opinion, is you need a guardian who is protecting this person and having the right to oversee what a trustee does or what an attorney, in fact, is doing with the ward's property. So, determining incapacity. I've explained the basic process, but this is a solemn thing to happen in a guardianship. The attorney who is representing the alleged incapacitated person sometimes does not have a difficult situation legally and ethically, because a fair percentage of the time, by the time a petition is filed, the person is profoundly incapacitated, and the examining physicians and others will issue written reports which will confirm something that is a fact and may have been a fact for some time. The attorney who is representing the petitioner, remember that the attorney has an obligation to the ward as well. And so this is not a matter of trying to railroad somebody into an incapacity order. It's a matter of making sure that the person's rights are cared for. The strongest policy decision for the court is to find the least restrictive alternative so that you are protecting the person's rights to the greatest extent that you can. Now, beginning the guardianship. Once we know that a determination has been made, the work of the petitioning attorney begins in earnest. There are initial requirements for the guardian. Most often with family guardianships, that guardian does not know what to do, what has to be filed. The guardian may not know that a bond may be required, that an inventory has to be filed within 60 days of the issuance of letters of guardianship, and won't know what letters of guardianship are. The attorney has to know those things and be available and be proactive in prompting the guardian and actually preparing the various documents that are involved. And once the guardianship is set up and a guardian is in place, then you have many things that may happen over a long period of time. Now, something to remember about this kind of a case that makes it different from many others. A guardianship may last for decades. If you have a person who is found to be incapacitated at age 50, this guardianship may go on for 35 years. And if it happens to be a younger person, say a 25-year-old who has psychiatric problems that render him or her incapacitated, then the guardianship can go on for many more years. So this is not a short time obligation for a guardian, and the guardian needs to understand that, because all of the things that my prior speakers were telling you about the filing of inventories and plans and accountings, these obligations go on annually, occasionally more frequently than that. And they go on during the life of the guardianship, which may be the life of the ward. Now, the guardian has to understand his or her duties. You heard the comment about the necessity for filing or for getting guardianship education. And the program is very important, but it doesn't tell you everything you need to know. The attorney has to be part of this process and prompting the guardian, because the guardian often will not know. If it is a professional guardian who has undergone many multiples of the education that a family guardian would take, should know, but also needs the guidance from the attorney. Now, in guardianship, there are lots of different proceedings. Now, I hope you all will take the time to write down all of the various documents that appear and are used in guardianship proceedings, because these are all very important. This is the list of guardianship forms from the Florida Lawyer Support Services nonprofit organization that edits and creates these forms on an annual basis. And there's more of them, and there's more of them, and there's more of them. So, oh, and by the way, these are not all the forms that are used in guardianship proceedings. And thank goodness, not all of these are used in every guardianship. However, there are many things that happen in the course of a guardianship that the lawyer either has to prepare or has to anticipate in order to protect the guardian and the ward in the well, just in the day-to-day life of a ward who needs help. Many things that go on in a guardianship require court order. The guardian, particularly a family guardian, is not going to understand that. And it is important for the lawyer in carrying out his or her role in a guardianship proceeding to keep the guardian informed, pay attention to what the guardian is saying, and know the status of the guardianship periodically. So there are many things that can't be done without court order. And that means that the guardian needs to communicate with the attorney, and the attorney has to say, wait a minute, you can't buy that. You can't sell that. You can't do whatever the guardian feels is needed without getting a court order. Examples are if the guardian is in charge of someone's car, and the car is sitting there in the driveway, and the hoses are all deteriorating, and the battery has long since gone, and the tires are going flat on the bottom side, and the car is now just a giant paperweight holding the pavement down to the yard. The guardian may not understand that a court order is required, which means a petition must be filed asking for permission to sell at a particular reasonable price, and notice must be given to next of kin. Likewise, if the ward's house needs new plumbing or a new roof, as happened when the hurricane went through in 2020 and right over the top of my house. Fortunately, I didn't have a guardian at that point, though many believe that I should have one at any time. If family members need to be supported or want to be, that requires a court order in advance as well. If a guardian determines that there has been exploitation by a family member or some helpful neighbor or someone else, the guardian can get court permission to file that action. Guardian's not going to know that. It's up to the attorney to troubleshoot that. And it's a major part of the attorney's role. I think my time is probably about up. As we finish up, this is one of my favorite cartoons, and it goes hand in hand with the fact that all of our wards and all of our guardians and all of the attorneys are facing that the last time before we die. I just want to remind you to think up some really long words to prolong your wonderful life in guardianship service. If you have time, and when this is all over, here are some books that you ought to read. Henrik Groen is a story of a man living in an independent living facility in the Netherlands, and he and his elderly friends, who call themselves the Old But Not Dead Club, keep finding ways to be troublesome to the administrators. A man called Ove is a very poignant story that opens with a man, elderly man, who's looking for the right kind of cord to hang himself. And through the rest of the show, he becomes much more constructive in his thinking. Empty Mansions is a true sad story about a fabulously wealthy elderly lady and how she is mistreated by her advisors and helpers. Shakespeare for Squirrels, just a modern trend on A Midsummer Night's Dream, which is the most performed of Shakespeare's plays. And if you read that, you will at least get a laugh out of my presentation. Thank you for your time. I'll be here for a little while. That's it.
All right, thank you, David. David Brennan, our attorney with a legal perspective for us. And I just want to let everybody know, and our panelists are here with us for questions. We've gotten a good amount of questions coming in, about 16 questions so far that we're going to get to, but I want to get to our last presentation before we get to those questions. And also just want to share that that any specific case information, we cannot get into or answer questions related to it because of confidentiality reasons, especially if it relates to mediation. So again, no specific case information, but we're going to try to answer as many questions as possible. So now for our final presentation, it's not often we can get insight from a judge, right? So we are very grateful to have Honorable Judge Leticia Marquez here with us, joining us to give us a perspective from the bench. Take it away, Judge.
Thank you. Good evening, everyone. I appreciate the clerk inviting me to join in on this. I always enjoy interacting with folks and trying to give them an idea of what it is that I do. I am one of the 3 probate judges here in Orange County. There are 2 probate judges in Osceola forming the Ninth Circuit, and we cover probate, guardianship, and mental health. I have been watching the questions come in, and I note that there's quite a few folks asking questions about guardian advocacy. So let me start with that. Very briefly, if you have a child with special needs, and if those needs manifested before they were 18 years of age, even if the child is more than 18 years old, you can file for guardian advocacy. The forms are quite on the Ninth Circuit's website, and they're also, the clerk, I think, not only has the forms, but you can get a packet from them. Could be wrong about that. If I am, someone from the clerk's office chime in and tell me I am, but you can get the forms either way. You don't have to have a lawyer. It allows you to make decisions for that now adult that you've been taking care of their entire life. You can hire an attorney if you wish, and you can hire the attorney just to get the guardian advocacy done and then move on to doing the rest of it yourself. What I'm looking for from a judge's perspective with guardian advocacy is, as Ms. Solomon Cuthbert told you, Winter, we work with every day, and we work with all of these folks every day, the judges do, and we're grateful for their help. Without them, we wouldn't be able to do our jobs. What I'm looking for in a hearing on a guardian advocacy is that you've passed the background check. By statute, if you have a prior felony, you cannot serve as a guardian or a guardian advocate. There are exceptions that a judge can make, and I have made some in the past, as have some of the other judges. For example, if your conviction was when you were 18 years old and didn't have the sense God gave a duck, as none of us do when we're 18, but you're now 42 years old, you haven't committed any crimes, you've lived a good life, judges are likely to overlook that felony. But by statute, if you have a felony, you are barred without the waiver from a judge. And the other thing we're looking for, if you're going to be handling money. Now, a lot of people with special needs, the only money they have is Social Security. And that's governed, Social Security watches that money. But if you're going to be handling money and assets, inheritances and such, we are going to look at your credit report. And again, what we're looking for is to make sure that you're going to responsibly handle this money, because the money is there for the benefit of the ward, who in this case is your child, who's no longer a child, who's now an adult. So that in general is what's happening with guardian advocacies. We're looking just to make sure that you can handle this, and you must be able to prove that the person's special needs manifested before they were 18 years of age. If you don't have that proof in the form of medical records, someone was treated for autism, for example, school records, many folks with developmental disabilities went to special classes, so school records can prove that. That's the kind of thing that I'm looking for in the court file. The examining committees are not appointed for special needs for guardian advocacy. I just need a medical report with the petition. That's a quick overview of what the courts are looking at when we're looking at appointing folks for guardian advocacy. We are going to require you to file an annual plan and a physician's report. The point of the annual plan, quite frankly, I have approximately 1,800 cases, as does each judge in this division. I cannot possibly supervise 1,800 cases without some reports. Those annual plans tell me it's a series of questions. The form is on both websites, the clerks and the Ninth Circuits. Those annual plans tell me what I'm looking for is the ward doing okay? Do we need to provide you some additional assistance? Every once in a while, we get an answer from a parent that says, you know, I'm 80 years old now, I'm 78 years old now. I can't handle this anymore. I need some assistance. That triggers me appointing Winter to come in, start to see if you've got all the services you need, maybe make a plan to transition someone to different housing. Maybe you haven't signed up with the agency for persons with disability. That's the kind of thing the court is looking for. We are not looking to remove your children from your home. And the one thing I want to stress to everyone is, even if you are not appointed a guardian advocate, someone else is, because, for example, you have a felony in your background and we can't appoint you, that does not mean the child isn't going to live with you. It just means you're not going to be the person handling the money or making things like medical decisions. The guardian will consult with you, but because of the law, someone else will make the decisions. But we're not removing people from your home. That seems to be one of the biggest concerns that parents have. And I understand that completely. You should never be afraid to ask a court for help in that situation. You should never be afraid to come to court and say, I'm struggling, I need help, I need some assistance, I need somebody to help me apply for benefits, I need to make sure my kid's getting all the benefits they need. Those are the types of things the courts exist for in the guardian advocacy cases. In the adult cases, where someone doesn't have special needs, they're simply an adult. And I did notice several of you have asked, if a child with special needs is over the age of 18, you can still apply for a guardian advocacy. So I'm going to move on from that. This is now, you have an elderly parent, you have a spouse who's been in a car accident, sustained brain damage. We have several of those types of cases where someone is unable to care for themselves. They are incapacitated. Incapacitated to a court means they cannot make decisions. Now, it's not that they can't make good decisions, they just can't make decisions in certain areas or in all areas. The most common cases that we're going to see are dementia and Alzheimer's, which are progressive diseases. We've had cases where folks come in early, and the way you do this, ladies and gentlemen, is you simply file the petition. You hire an attorney if you're filing for a regular guardianship, and they're going to file a petition for a guardian to be appointed. In all cases, including guardian advocacy, we're going to appoint an attorney, this is the law, to represent the AIP, the adult in need of services. That's who they get, their own lawyer appointed to make sure that their interests are represented to the court. But you file the petition, we appoint an examining committee. It's 3 people, one of whom must be a doctor, to examine this person and report back to the court what capacity, if any, this person is lacking. If 2 people tell the court this person doesn't lack capacity, the case is over, the guardianship petition is dismissed, and we move on. Oftentimes, the examining committee members have different opinions. Some will say this person can't marry, vote, make medical decisions, but they can make decisions about where they're going to live, their social decisions. Those are the types of issues that are resolved during hearing. We can take testimony at hearings. We can have an evidentiary hearing. We've had contested cases where folks are, children are arguing about who should be the guardian and why they should be the guardian. They're arguing about what kind of capacities parents have or don't have. Sometimes you appoint one person to handle the person, make decisions about residency, that type of medical issues, but there's another person. I'm remembering one case where one of the siblings was a certified public accountant. So that sibling became the guardian of the property since money is what they did. Again, you will have to undergo a background check. What the court is looking for is someone who can make decisions for the ward based solely on the interest of the ward. The job of the guardian is to protect the ward, and the only job the court has is to protect the ward and make sure that the ward gets everything that they need during the guardianship. That's why we require the annual accountings. That's why the clerk goes through them, reports to the court. I've seen these types of issues in the accounting. I've seen all this money going out. There's no receipts. There's no explanation for this. Those types of things are going to trigger a response from me. You're going to get a notice to come into court and explain to me what happened to this money. If I don't like the answer, if I don't think, and sometimes the reason folks are doing things wrong isn't nefarious. It's not because they're stealing money. It's because they actually don't know how to handle money. Sometimes the reason is they're stealing money. If you're stealing money, I'm going to take further action. You're going to be removed, and it's going to be referred to the state attorney's office and the sheriff's department for investigation. It is theft to steal from wards. If it's just a lack of knowledge, oftentimes just talking through it with the guardian or having Winter talk to them or their attorneys, we can straighten it out. We can figure out what's going on. Our goal is not to make the life of the guardian difficult. It is to make sure that the ward is getting everything that ward needs and that the ward's money and assets are being used for the benefit of the ward and not for the benefit of everyone else. Guardians get paid. We do appoint professional guardians. Oftentimes, the folks that come to us do not have family. It's sad, or their family members do not want to take care of them, or they can't. We can't appoint them because felony convictions, bankruptcies, all kinds of issues. Those folks will be appointed a professional guardian, and those professional guardians are paid. The rate set in the Ninth Circuit for professional guardians is $70 an hour. They have to file affidavits. They have to file petitions for the court to approve those fees. We have had hearings. All of the judges have had hearings where we have disallowed some fees. For one reason or another, we just didn't feel like that was reasonable. We've sometimes said, we're going to reduce the rate for this because this is less a guardian function than, you know, a function of, for example, if you went shopping for something the ward needed, it doesn't require a professional guardian to do that, but it is help to the ward. So we're going to pay you something. It may not be $70 an hour. I'm trying to go kind of look through these questions and make sure I cover everything, but in the guardianships, the statutes are fairly clear about what we're doing when we appoint someone. I know there's been a lot of controversy in the news about professional guardians and some of the professional guardians who have unfortunately done things they shouldn't have done. We have a lot of safeguards in place. I have to give kudos where kudos are due. The clerk's office here has really stepped up their game on auditing those annual reports, on catching things, on bringing things to the judge's attention very early, letting us know that there might be a problem so that we can intervene as early as possible in those issues and try and prevent anything from happening. If we are notified that a professional guardian has pending investigations, we certainly take action. We follow those investigations closely, and we are notified by the office that supervises guardians when complaints have been filed and there's investigations against guardians, and we do track those and keep an eye on them. I don't know what else I can tell you about this from the judge's view. There's a limit to what I'm allowed to say during these proceedings. People don't realize it, but there's judicial canons that don't allow me to tell you how I would rule in a certain situation. I just have to speak in generality. So I'm trying to be very careful about that. And I'm not sure it wouldn't be more I think Mr. Brennan wants to jump in on something. I don't know, but I'm not sure it would be more productive if I just answered questions, but it's up to the moderators how they want me to do this.
Yeah, Judge, we appreciate, we're definitely going to look at the questions. I like to verbally read the questions out and then give the answers so everybody on our webinar can hear questions and answers. So we'll get to that shortly here. But first, first, we appreciate you, Judge Marquez, for being here and for your presentation. And before we get to the questions, we now have Orange County Clerk of Courts, Tiffany Moore Russell, who is joining us, and I want to bring her in so she can bring some insight into the clerk's office and why we do these legal forums, and hoping that all this has been very informative for everybody who's been part of our webinar. Clerk Russell.
Thank you, Dane, and good evening to everyone who joined us this evening virtually to partake in this very important legal webinar. Allow me to thank Attorney Brennan, Winter Solomon, Cuthbert from Court Administration, and of course, the wonderful Judge Marquez for serving as our panelists, and of course, our team from Probate and Mental Health. I see Manager Michael San Giorgio, Tamika Brown, and Mighty Moxley. Thank you so much for providing your expertise. And of course, always a huge thank you to my communications and public outreach team for continuing to bring this very important platform to our customers and to the citizens of Orange County. So I hope you found this information useful and that you now feel more knowledgeable about the process. But I will not talk anymore because I know you said people have questions and they really want to speak to the expert. So Dane, I will again just thank everyone for coming out tonight, and you can go to the question and answer.
Great. Thank you, Clerk Russell. We appreciate it. I do want to share with everybody that's on the forum with us that it was Clerk Russell who was a priority of hers to bring these legal forums free as a service to the community. So we hope that this is good information for everybody who's joined us. So getting to the questions. The first one we're going to, and we've got about 19 of them, so we have a good amount. First one actually relates to our office, and the question is, what criteria do the clerks base the audits on? So Métis, if you could help.
Hey, Dane, I'll take this one.
Okay,
So
Michael.
Our criteria is based on the Florida statutes, of course, general accounting principles, and then any requirements that the judiciary may have. We work hand in hand with them. Also, to add on something that Judge Marquez said earlier, we do in fact have the guardian advocacy forms in our office at the courthouse, so they can come and get those there.
Mhm. Good.
Yeah, anything you want to add, David?
Not to that one. I'm looking at the second one.
Okay, yeah. So the next one we have is my father has advanced directives, power of attorney, healthcare surrogate, and preemie guardian. Everything I read says that will stop a guardianship. Why are they not honored in Florida?
Well, that's an interesting question. They are honored in Florida, but nothing is absolute. I'd said, and I think others spoke to the issue of the guiding light is to find the least restrictive alternative. And all of those advanced directives would constitute least restrictive alternatives and may be a good reason not to have either a guardianship of property or a person, depending on circumstances. But the whole point is the protection of the ward. And there are situations in which the person who is named agent under a power of attorney or a healthcare surrogate may have problems that would make it inappropriate for that person to be guardian. The judge talked about someone who has been convicted of a felony, for instance, or may have other problems or clear conflicts of interest that would make that an inappropriate appointment. So I really can give no yes or no answer because there is no such thing. And it's the maddening point about the law, I guess. But it's all about protecting the ward. That is more important than the documents.
If I could jump in briefly, we do not refuse out-of-state pre-need designations. It's not the law in the state of Florida, and we don't refuse them. If they're correctly done, they name a person who's willing to serve, and the ward is found to be incapacitated. You still have to make, a lot of people don't realize this, someone has to be found incapacitated to trigger powers of attorney, healthcare surrogacy, and all of that, because you retain the right to make decisions until a court says that you're incapacitated and can't make them. But we don't reject them just because they're out of state. That's not how this works. They are valid in the state of Florida.
Sure.
Great. All right, thank you. Next question. My son is 26. Can I still do his guardianship?
I believe the judge answered that
Yeah.
in her main presentation. Yeah.
Yes, you can.
Yep.
File those guardianship advocacy forms if you can prove the need developed before they were 18.
Okay, great. Moving on to the next one. There are several professional guardians currently operating in Florida who recently filed bankruptcy, have lost civil suits. What is the criterion to deny a family member guardianship based on a credit check? Do the same rules apply to the professionals who have influential probate litigators as their sponsors? Let's tackle that one.
That's what I get paid the big bucks for. I'll tackle it. Professional guardians are licensed and governed by the state of Florida. If a professional guardian has filed bankruptcy or is involved in a civil suit, by all means, you should report that to their agency, whose name just went right out of my head because it's been a really long day. It's the
Office of Public and Professional Guardians.
Thank you, Winter. That's her job, is to bail me out and make me look good.
Wish
So
I had someone like that.
if you, oh, you do, I know your daughter. If you have that information, by all means, provide it to that office and provide it to the courts if you happen to know they're serving on a certain case. Again, courts do not go out and create their own investigation. Something triggers us to investigate. Either we're notified a guardian's got an open investigation, a family member notifies us of something. You have to trigger reactions from courts. We're not, in fact, it's not our job to initiate actions.
Okay. Next question we have is someone's asking, should I apply for the guardian advocate representative?
If it's appropriate for there to be a guardian advocate, then I would assume the parent would primarily do that. Yes.
Yeah.
And sometimes siblings will do it. You can do it if the parents for some reason can't, a sibling can do it.
Yeah, I forgot there was a two-parter here. Was should I apply for guardian advocate representative because she can't do it for herself? Again, she's 20. So I think this is a parent.
Yes.
Okay. All right, next question. My son is nonverbal autistic and turns 18 in December. I will, of course, continue to be his caretaker and need to know how I go about applying for guardianship. Are you saying I need to obtain an attorney myself to apply to be his guardian?
Guardian advocate?
You do not. If it's a guardian advocate, which this sounds like it's a guardian advocacy, you are not required to have an attorney. The clerk's office can provide you with the packet. The forms themselves, they're not, you'd have to print them out from the Ninth Circuit website, but they're there. But you can do a guardian advocacy without a lawyer. Or you can hire an attorney to get you through the initial part of getting the guardian appointed.
Yeah, and this next question says, how much is it to file paperwork? I assume for guardian advocate.
I don't know the answer.
To file the paperwork.
I don't either.
Okay, so to file the paperwork for a guardian advocate is $235.
Thank you.
Thank you, Métis.
And the clerk's office does great public service in this area. They really do.
Thank you, David. We appreciate that. All right, next question. Where do I go on the website to obtain the application to apply for guardianship of my son with autism?
I think that's just been answered. And it's on the clerk's website, right?
Well, the packet can be picked up in room 335, right? Of the
Oh.
clerk's office.
Yeah, it's actually available on the ninthcircuit.org.
Yes.
And you can come in person to room 355 as well to pick up the package.
Yeah, and the ninthcircuit.org, go to forms and click through until you see the guardianship forms.
Correct.
And then we have all the guardian advocacy forms posted there. Again, you have to print those yourself or you can pick the packet up.
Okay. Thank you for that. Moving on to the next question. Why are court-appointed lawyers only paid if their client, the alleged incapacitated person, gets put into a guardianship?
That's not correct.
No, that isn't correct. And we've been working on new legislation to make that much more clear, because there have been questions raised about that. There should be no connection between the court-appointed attorney who represents the alleged incapacitated person and whether that person is found to be incapacitated. And we don't want to give incentive the wrong way.
Gotcha. Okay. Next question. Why are guardians allowed to serve on the examining committee? Is that true? And why?
Can be. The statute requires the specific things from examining committee members. They have to be psychiatrists or other physicians or have special skills. Sometimes guardians have as much experience dealing with incapacitated people and what constitutes incapacity as people in other professions. In my experience, it's very rare that a guardian qualifies, but I've known some who have.
We have guardians who are registered nurses. We have guardians who have specialized degrees in mental health and in elder care. You can serve on the examining committee, but you cannot be the guardian of a person if you were the member of the examining committee. You can't do a dual role.
Okay, that's probably the answer there. Not a dual role within a specific case. Okay, next question. Does anyone get out of guardianship?
Yeah, I let someone out today.
Sure.
It's a suggestion of capacity is filed, indicating the person no longer needs a guardianship. By statute, a doctor, a psychiatrist must examine them, provide the court with that information. If all parties agree, including the doctor, that they have regained capacity, you don't even have to have a hearing. If there's some doubts or if they've regained some capacity, you have a hearing about it. But I've restored several people to capacity. In fact, it's one of the things I most enjoy doing is signing those restorations of capacity and releasing folks from guardianships.
Yeah, I absolutely concur. I think that's one of the happier things that happens in guardianship. And I'm thinking of a young man who was crossing a street and got hit by a car and suffered serious brain damage. And it took several years, but his therapies were successful and he was ultimately restored to full capacity. And that, yes, it can happen. People do escape. And by the way, I think that diligent guardians can observe whether they think it's appropriate for a person to be restored, and the plan that they file every year addresses that issue.
I've had guardians file the suggestion of capacity, asking me to terminate and I've had professional guardians do it, saying this person no longer needs me, you need to terminate this guardianship.
Okay, great. Thank you. Next question. How do I add someone to take over guardianship if I, as the mother, get ill?
It's called a standby guardian. And we signed those. I oftentimes sign, especially in guardian advocacy, you can plan ahead and you can ask the court to appoint a standby guardian. I will tell you that all 5 judges in the Ninth Circuit require the standby guardians, if they should have to become the guardian, to pass the background check. We will not sign off until they've passed the background check.
You recall in my presentation when I scrolled through that very fast list of about 500 forms, the standby guardianship forms constitute about a half a dozen of them.
Okay, Great, thank you. How about selling houses without certified property appraisals? Is that legal?
It's
Yeah.
legal, but no one in the Ninth Circuit allows it. No judge in the Ninth Circuit will let you sell a house unless you give us comps and give us appraisals so that we know that they're being sold at fair market value. I have denied sales before because the proposed price was below fair market value.
The role of the attorney, since that's my topic, includes dealing with the guardian about that. Sometimes the guardians, just of necessity, want to act fast because the realtor has given them 2 days to respond, and they're put under the gun, and that has nothing to do with whether it's fair and proper. This is one of those things where the guardian has to get a court order and has to give notice to next of kin. It just simply can't be done sideways and then hope that a judge is going to approve it after the fact. To me, this is something that's an important part of my job. And I'm old-fashioned. I like certified appraisals. I know that in some places, in many places, a comparative market analysis by a realtor is accepted, but it can't just be done without a reasonable showing of value.
Okay, thank you. Next question. My son passed away 2021. I've been co-parenting with him since 2014 of his daughter. She has now always lived with me, trying to inquire what to do. I need to file with courts to have total custody of her adoption. I need to have custody of her to even take her to the doctor, dental health care. What should I file with the court to get custodial rights, even for her health care?
Well, you've gone past me when you start talking about adoption, but people need to understand that adoption and guardianship are different things. Being a guardian does not require seeking adoption, and sometimes that's the family answer, and sometimes it isn't.
Adoptions are filed in family court. They're not filed in guardianship court. And I think those forms are on the clerk's website. In fact, I know they are. So you can look on the clerk's website and they have the adoption forms there. And there is the form for family adoptions. If you want to file for guardianship, it's guardianship of a minor. Again, you're going to need to get an attorney for this one, but you can ask for guardianship, but adoption is filed in family court.
Okay, thank you. So getting to our next question, what can Orange County do to increase the number of and the diversity of qualified attorneys that have the breadth of guardianship knowledge that Mr. Brennan describes? Now, one of the things I would say is the clerk of courts is ministerial and we do not appoint guardians. It's the role of the State Office of Professional Guardians, I believe, but anybody else want to chime in on that?
Is the question attorneys or guardians?
Question was attorneys.
Attorneys.
It's hard for the court to have a role in that, except with regard to the attorney for the alleged incapacitated person. I think that is well covered, at least in our county, by the court and the clerk's office. Beyond that, I'm not sure what can be said for situations beyond that. It's hard to tell people what attorney they can hire. Perhaps those of us who are older and theoretically know something about this ought to have billboards.
Okay. Thank you, David. All right, next question. The guardian is limiting my contact with my mother without a court order. Is that legal?
Well, there's been a lot of conversation among attorneys who do this a lot. I think the consensus is yes, you can do that. The person can then seek relief in the court. The conservative answer is you ought to seek a court order to prevent visitation, because wards are supposed to have the right of visitation. But the guardian has to protect the ward, and so there's a lot of pressure on a guardian in a situation like this. There's not an easy answer to it. I have seen it done that way, and I have filed petitions to limit access. And normally, it's a question of trying to prevent emotional and psychological abuse of a ward.
All right,
It-
David, thank
It's
you.
certainly something the court will entertain a motion on and have a hearing on to determine the basis for any ward being restricted from seeing family or friends.
Yeah.
But the court's not going to get involved unless somebody files a motion and says, Judge, this is happening and I'd like you to rule on this.
Thank you. Okay, great. This next one I can answer. It was a question about getting a copy of our presentation, and that all presenters have been awesome, and thank you. Yes,
Wow.
so as far as a copy of the presentation, the easy way for any and everybody viewing this to see it again is it will be on our website, the Orange County Clerk of Courts website, and our social media pages. And our website is myorangeclerk.com. You can view this entire webinar from there. Next question, the court limits professional guardians to a rate of $70 an hour. Do you also limit the rate and hours their attorneys can charge?
We review the rate and hours charged by attorneys. And all of the judges have had hearings before with attorneys about their fee petitions. You have to give people an opportunity to be heard. So if we look at the attorneys, just like the guardians, have to file an affidavit of time and services and rates, and they have to file a petition to have their fees approved. We review them in chambers, and if we have questions or do not think something is appropriate, then the attorney will be notified to set the matter for a hearing to take testimony as to whether or not those fees should be awarded. And I know I'm not going to talk for the other two judges, but I'm fairly sure they have also, but I have reduced attorneys' fees before and found some things not to be compensable, or not, that I'm not going to have the ward pay for it.
Fair enough.
Yeah. Okay, next question. Should a guardian's employee get paid the same as the guardian?
What?
I'm not sure what that means. Should
I
a
don't know who a guardian's employee is.
employee get paid the same as the guardian? So that's just not very clear what type of employee, right?
I don't know what,
I'm not sure about that either.
I don't know what
Okay.
the question is here.
All right, so moving on, can you explain the difference, pros and cons between a guardian and guardian advocate?
Mr. Brennan?
Well, a guardian advocate is appointed, and a guardian advocate, as has been said here, does not require the petitioner and proposed guardian advocate to have an attorney. It is for situations where you have, and by the way, I'm not involved in these almost never, because people don't need me, and I'm sure they consider that a good thing. But it is for people who have, I think it's limited to those who have birth problems, and they require assistance with not necessarily all, but substantially all of their activities of daily living and decision making. That's as good as I can do.
The guardian advocates are limited to those folks who have special needs, and those special needs manifested before the age of 18. Those are the only wards that qualify for a guardian advocacy. And there is no finding of incapacity with guardian advocates. We simply find that there is some sort of special need that must be addressed by appointing a guardian.
Okay. Great, thank you. We're getting towards the end of our questions here. Next one is, why does Orange County accept professional guardians that have over 800 wards? Now,
We
whether
don't.
we do or do not.
Winter, do we have any guardian that has over 800 wards?
Of course, they can have wards in other
We-
counties, right? So,
We don't know of anyone who has over 800 wards. Over the passage of time, maybe, I mean, if somebody's been doing this for 30 years, I suppose that's quite possible that over the 30 years, you've had 800 wards. But I don't know of anyone who would have had 800 wards at one time.
Well, I can say that I have never heard of such a thing, although there was a publicized case that made a big deal of a guardian who had a whole lot of wards. I've represented guardians who have had, I don't know, maybe 20 or 25 or 30 at any one time. When applications are filed and a guardian lists all of the wards for whom he or she has been guardian, there may be cases that were closed 5 or 10 years ago,
Right.
which is different from having 800 guardians currently. I don't think that's possible.
That's not possible.
okay, great. Next question. I have guardian extended family. I've had her from birth. She is now 14. How can I adopt her?
Family court. The forms are online at the clerk's website. You're going to need to file a petition for adoption and file all the forms. You don't have to hire a lawyer, but that's one of those proceedings where you might want to, but the forms are all online on the clerk's
Yeah.
website.
Okay. Next question we have is, what is the CLE code for this? Well, we don't actually have one, as this is a public education webinar, so there's no actual CLE code that we have for this legal form. Next question, why don't they cap the number of wards? Do they cap the number of wards? Do they not?
The courts are here to serve whoever needs us. We don't limit the number of people that we're willing to serve.
It
I
might
don't know
be,
if that's the question I'm being
guardians.
asked. Yeah.
Yeah, I think it's, do they
I've
cap?
got a feeling that the question goes to limit the number of wards a guardian may have. I think it goes back to the prior question we talked about.
There's no, that I know of, no statute that limits them. There isn't an, again, as Mr. Brennan pointed out, when a guardian fills out their forms, they have to tell us how many wards they have. And if we had a form from someone telling us that they had, way too many wards, the court would simply move on to the next guardian.
The public guardians are limited, but they are limited by the number of employees they have.
Right.
Yeah.
So those are the only ones who are limited by statute.
Okay, great, thank you. Next question. If I have durable power of attorney for a special needs family member, do I also need to become guardian advocate? And what happens if we move out of county or state?
Not sure how you got the durable power of attorney in the first place. For a person who, before the age of 18, needed a guardian or guardian advocate's assistance. So I would say, yeah, you ought to. The power of attorney may be questionable in the first place.
Okay, thank you, David. And I think we're down to our last question. What is the best? Well, no, another one just came. All right, here we go. We'll see if we can get there. What is the best way to help with an adult child who's not complying with her mental health, making wrong decisions? Does a parent need to file for mental incapacity to get a guardianship from the court?
All right, I'll jump. these are among the most difficult guardianship cases. If it is an adult child who has not been determined to be incapacitated, the scenario that I see with unfortunate frequency is a child who is bipolar, a child who is schizophrenic or has some other psychiatric condition that periodically makes that child unable to make safe and rational decisions. It is very difficult. A guardianship often is needed, and it's hard on the judge, and it's really hard on the parent. This is one of those cases that could go on for 35 or 40 years, and maintaining any level of discipline can be virtually impossible, and the child will not thank you at all. Because he or she is just simply unable to understand. And that's part of the reason the guardianship is needed. But this person may get on a regimen of medication and improve and be perfectly fine in the eyes of the people at Starbucks or wherever. And then the syndrome is the person is so much better that he knows he doesn't need the medication anymore. And so we're cycling down into what is really total incapacity. And so it revolves. I don't have a good answer for it because I can't think of anything else. But to seek guardianship, if the parent has the energy and I don't know what else to say about it. It's going to be a tough life for the parent.
I can't add a whole lot because this is in that gray area where judges aren't allowed to say much. First of all, I have nothing but sympathy for folks that deal with family members who have mental illness issues. It's just very, very difficult. Guardianship is only allowed when a person is incapacitated. So if someone is incapacitated due to their mental health condition and all of the proof is offered to the court and the statutory requirements are met, a court can appoint a guardian. However, as I spoke earlier about the suggestion of capacity, which by the way, can also be filed by the ward, when that person regains capacity, which happens frequently with folks who are mentally ill, take their medication and they regain capacity, the guardianship must be terminated. And if they then again go off of their meds and get to the point where they are incapacitated, the entire cycle would start again. We don't have a good answer.
Gotcha. Okay. And then we have a follow-up to that one question about durable power of attorney. She said, our participant said she received it from a pro bono attorney. So if you recall that question, I can go.
Is that the one about moving out of state with the durable power of attorney?
Correct. Yes.
Here's the part I can answer. If your durable power of attorney is valid in one state under the full faith and credit clause of the United States Constitution, it is usually valid in another state. That's why out-of-state wills are valid in the state of Florida, so long as you meet certain requirements.
Exactly. I don't recall addressing any geography in my discussion of that issue.
The issue as to whether the original durable power of attorney is valid is, I don't have an answer for that. That would be something that would have to be litigated, I assume.
Okay. All right.
got it.
Well, we've got through it, and we've been going for nearly 2 hours. So thank you, everybody, for joining us.
With no CLE, but thanks for
Yes.
coming and just for the enjoyment factor.
Yes, and the education for the legal forum and information. So we appreciate all our panelists joining us, and for everyone who also joined us tonight for this forum. Orange County Clerk of Courts Tiffany Moore Russell, of course, understands the importance of these conversations in our community, and providing free legal forums is one of Clerk Russell's top priorities. We hope the topics discussed were helpful, informative to you. Again, a big thanks to all of our panelists. And also, I just want to remind you that once posted, you may view this entire video of this webinar anytime you'd like on our website, which is myorangeclerk.com, or our social media platforms. You can follow us on Facebook, Instagram, Twitter, LinkedIn to get all latest updates from the Clerk of Courts. Thank you for joining us. And also, once this session ends, if you will please take our survey. We have a survey at the end of this that will pop up for you to take. Helps give us feedback on the topic, other topics you may want to hear about, as we do try to hold these legal forums at least twice every year on different legal topics. So please take our survey. Thank you, and everybody have a great evening.